This is Foundation second class, and you are welcome. For the sake of introduction only, myself is Manu Jindal. I'm an advocate in India and barrister and solicitor in Canada. But still, I'm in India and I have not opened up my practice in Canada. I'm with you, teaching you Foundation. This is our second class. Of course, this is a no-fee class, but I still try my level best to tell you what is contained in the NCA's Foundations of Canadian Law. Now, before we start this class, let me ask you that since we have covered the whole of the chapter 1, that is the legal theories of law, upon which the whole of the law or judges' decisions revolve. So may I ask if anybody has got any query before we proceed further? Of course, we are going to revise it, but before we proceed further, I want to take up queries, if any. If everything is good, then we shall continue. Let us revise that we studied in the last class. There are theories of law, and theories of laws are like legal positivism, natural law, critical legal theory, feminist legal theory, law of economics. These 5 theories we read in the last class. And let me say you one thing. We have not read chapter 1. And if you are going to ask me one frank question that how many marks exam is to be there from this first chapter, let me say you that if you are to attempt any question in the foundation exam, then you have to use this chapter. As I told you one tip last time, that it is mandatory. I'm using the word mandatory to take syllabus with you in the foundation exam. The second tip, which I have already given you still for at the sake of repetition and in a clear-cut methodology, I am here to tell you that you need to keep in mind every theory, means to say these 5 theories and cases mentioned therein, when you start attempting your foundation exam. Because the examiner is looking forward that which is the relevant theory, which is connected with the question. If you put few lines, few words or a case law appropriately as per the exam question, then I suppose you will be very good. The examiner will come to know that you have the full grasp of the question. You are bound to get good marks. Of course, there can be independent question from this chapter, from any theory, from any case law, from the article. The article and case laws we are going to read today itself. So the point in question, the second tip for the exam is this chapter, which people hardly pay any attention. They must remember, I'm using the word must. They must remember that this is something backbone of the whole foundation syllabus as far as NCA is concerned. Moreover, the cases which we will going to read, you will be agreeing with me after we have gone through those cases that the legal theories are the guiding principles for all the judges, lawyers, what should I say, the legislatures, to make, implement and enforce the law for the people in general. So once you are conversant with the theories, the basic concept which is there in the theory, then you will be good to handle any case. Of course, when you are arguing a case before any court, particularly the Court of Appeal or the Supreme Court of Canada, then one day you may relish this thing that foundation happens to be that subject which has made real plinth for your professional career in Canada. Of course, it seems to be a little boring or theoretical, but let me say you, if you keep enjoying this subject, then you will be very good in your profession. So the second tip, I repeat that you need to use these theories in every question you attempt in the exam. You are bound to get few marks for on account of this. Even if you say, God forbids, you attempt the main concept wrongly or the semi-main concept wrongly, even if you have put legal theory correctly imbibed into your answer, then you are bound to get marks. And getting marks in foundation is very important, because even after attempting the whole of the exam, you may come to a conclusion that you have attempted a question wrongly. Because that is why the first tip will come to your rescue. That is, you need to identify the main topic. And for that purpose, the foundation NCA syllabus is there to help. Of course, we will learn in the due course how that is going to help. Before we proceed further, let me recall you little bit, and there is one pending question of the inclusive and exclusive positivism, which one of my friend asked in last class. And first concept we read, this is just a revision of what we have read in the last class. Legal positivism means rule is a rule is a. That is a basic concept. And the case law we have gone through, Noble versus Wolf. This is what we have gone through. And I have posted notes in this WhatsApp group. And those notes are very appraised. You can use in your own language in the exam. They are good to write in the exam. You can pick the appropriate point for the examination purpose, write it over there and get the marks. So these are not like a bookish knowledge. This is very simple. It is in your own what I should say, that it is your own writing, own thought process, which you should put directly into the exam. So Noble and Wolf is a very famous case for legal positivism. Let me clear that question as well. That is inclusive and exclusive, positivism. Positivism is a rule, is a rule, is a. There are few thinkers who believe that the rule should be in concurrence with the moral principles to certain extent. If the rules are not in concurrence with moral values, then that positivism is of no value. These are those thinkers which we called as inclusive thinkers. That is also called as inclusive positivism. So the key point to be remembered for inclusive positivism is that if the laws are in concurrence with the moral values, then it is a good law. Now come to the opposite, exclusive positivism. Of course, these can be discussed in detail, but this is not for the NCA purpose. There are few research papers which has been written by various university scholars on this. We can go to any extent to discuss that, but there is no need as far as NCA syllabus is concerned. The second comes out to be the exclusive, which is exactly the opposite. They say that for a rule to be a rule to be a rule, they should not be in concurrence with moral values. Rule is a rule. So there is no requirement that they should be in concurrence with the moral values. Once a rule has been framed, it should be implemented in its totality. So that is known as exclusive positivism. Am I right? And are we good to go with this inclusive and exclusive positivism? I suppose the friend who has asked this question is not there today in the class, but still, if anybody wants to ask anything about positivism. Now, I have not covered in my notes because, of course, I have heard that there was a question few years back on this. So for that purpose, but I am not sure because the NCA never says that inclusive and exclusive positivism, because if we will keep on trying with the inclusive and exclusive positivism, then of course, there are certain other topics which we need to cover. But these two lines are sufficient if a short answer type question or reference is there in the examination. Now, second comes the natural law theory. Natural law theory, morality is the first principle which should be there when you need to implement it. I given you examples, the famous case, Drummond case, which is a good case, means to say whenever you have to apply law, you have to keep moral values with. Third comes the critical legal theory. Critical legal theory, R versus RDS is the case. And you should remember, I have written in detail in my notes that critical legal theory is a theory which always says that you should interwove the socialistic, political, as well as economical principles when you have to implement a law. So if you go by this critical legal theory, then they depose, we have discussed at length, R versus RDS. You have to include that whenever a person is to implement a rule, suppose a police officer, I will give you a new example. A police officer is there to arrest a person. The person happens to be a black person, then he will have a different aptitude. If a police officer is there to arrest a white person, then there will be then that person would be uh, having a different aptitude. So what I'm trying to say, every judge, the human element into the implementation of the laws, which is guided by social, economical, and political considerations, cannot be ruled out. Whenever a judge needs to decide a case, he, of course, he needs to appreciate the facts and evidence on the record, but he would always have imprint of his life experiences, whatsoever he or she has experienced during his lifetime, into the decision of that case. That is critical legal. So no implementation of the law, no interpretation of the law is without the touch of a human element. So this theory cannot be ruled out. Even if a judge is making a remarks against a certain person, that can be covered under bias. And bias is a very good, like we have the my learned friends who have appeared in this admin law might have come through the whole concept of bias. So critical legal theory is based on the concept of bias. But here we cannot call it exactly the bias aptitude. We will say that the life experiences or the life what you should say, that the life learning lessons have an imprint upon the decision making process of an individual. That individual can be a judge, can be a police officer, or can be an administrator. So this is what critical legal theory thinkers say. Now comes the feminist legal theory. We have read that into two parts, early feminism and to the contemporary feminism. Early feminism talked about two things, like earlier the woman never had the right to vote in Canada. After 1918, the women were empowered to vote in Canada. Then they traveled their path to become senators of Canada. So this is something feminist legal theory, that women took a revolution, and by way of that revolution, they reached to become senators of Canada. I have put it in my notes that there is one case by the name of Edward versus AG Canada. We have discussed last time. every government were coming. 5 governments came and went. Everybody wanted that. Everybody given their statements that the woman should be in the Senate. But they made a lame excuse by saying that since there is since there is DNA Act which describe the person to include only men. Once the law says so, so they cannot do anything. And ultimately, the Supreme Court of Canada came to the rescue by way of person's case and given the power to women to become the senators of Canada. So this is about early feminism, which we have read in detail. Then we read about contemporary feminism. Contemporary feminism comes to when the women say that they have a right to decide everything about themselves. We have read R versus Morgan Taylor's. Morgan Tails, that is a case which describes whether Section 251 of the Criminal Code of Canada is ultra virus to the Section 7, which pertains of the Charter of Rights, which pertains to the life, liberty. In 1982, if you start keeping the historical perspective of this, 1918, when the women were not entitled to vote in Canada, then they traveled little more path. They became entitled by the time they reached to person's case by the year 1940s. They became entitled to become senators of Canada. Then after becoming that, they still continued with their evolution and tried to tell the people that they are empowered to decide about their body, about their decision-making process, particularly that whom they want to give the birth and whom they do not want to give the birth. This is still a topic, but it has taken a different shape in US politics as well as in Canadian politics. The point in question has been that if a woman wants to abort a child, whether it should be her prerogative or not. It is still a political issue more in US than in Canada. But in Canada, by R versus Morgan Taylor's, one point is clear that a woman is entitled to decide about the baby she is carrying in her womb. The point is that Section 251, subsection, if I'm not wrong, subsection 1, that has been declared to be ultra virus, the constitution, and has been deleted because that violated the Section 7 Charter of Rights. I was telling you the historical perspective, 1918, 1940, just to make a note on your mind. You can remember these points like this. Suppose 1980 came the early feminism, 1940 came that case, then came by which the women became senators, then 1982 when the charter was implemented. I suppose everybody knows that when the Canadian charter was implemented, it is 1982. So once the women came to know that the charter gives them right to equality as well as right to life and liberty by way of Section 7, and any law which contravenes the Charter of Rights can be declared unconstitutional, then they took their fight to this extent that R versus Morgan Tails came by the Supreme Court of Canada, and by that law, it was decided that woman has got right to decide about her own self. And Section 251, subsection 1 was declared invalid. So my suggestion to all of you, this is the way you can remember. This is the way how you can remember, and of course there are notes, and you have to bring whenever there will be questions. Let me say you one another thing. There will be a fact pattern in the exam. Somebody in the group has also posted a question. I never try to solve that for the simple reason we need to go through the whole of the syllabus. Only then we will be in a position to identify the main topic, subtopic. Then we will be in a position to say that what sort of law or what sort of article should be intervened into that. Then what sort of theory should be there. Only after reading first chapter, we cannot solve any question. That is my humble suggestion to all of you. While revising the previous class, let me go few steps further. Law and economics was the last theory. Of course, from the next class onwards, we will be going a little faster. But for benefit of all of you, I am covering the previous class, law of economics. Means to say that when a plaintiff or a petitioner files a case in the court of law, if it is for a value of a money, then when it is decided, the value of the money should be that. Suppose case is filed today, it is decided after 4 years, 3 years, the defendant should not take benefit out of that. Suppose today the value for the petitioner or the plaintiff is different, and tomorrow the value for the petitioner or the defendant is, of course, he or she will be always at a advantageous position, but value for the petitioner will be different. So the court held by way of this theory that there should be a change in the aptitude. There should be, what do you call it, simple interest should not be applied, compound interest should be implied, so that the defendant should be penalized to pay for the fruits they have reaped, for the simple reason that the plaintiff or the petitioner should not suffer on account of delay in justice. The case which I told you last time is Bank of America Canada versus Mutual Trust Company. So I have cleared all the facts in my notes as well. We have discussed last time. So this is all about our last class. Before we go further, let me ask you if you have any questions. Let us go further. Now, as I told you, let us go to the syllabus, which is the backbone of our foundation. Of course, the first chapter and the syllabus. Syllabus tells us the first case. I told you to write something sentencing case framework. Now, I will be, of course, giving notes of this 3 cases, as well as 3 cases, R versus Morris, Canada Incorporation versus Kelly Shepherd, R versus Gladue. Before we go into the details of this case, may I ask anybody who has gone through these cases? Nobody tries to interact. I suppose everybody may be hesitant. I do not pinpoint. In regular classes, we will be pinpointing so that I may come to know that nobody is sleeping, at least. So once the class will be in having an interactive mode, I suppose then it would be better to grasp the facts as well as to grasp the things which we learn every class. Otherwise, foundation, when we were studying NCA, we found the viewpoints of many of our colleagues. They told that the foundation is really boring subject. And by the end of the day, all of you have to attempt this paper in the examination. And sorry to say that many people who attempt foundation exam face problems and many fail. The reason is only this, what I could preclude from my own experiences, that people do not take interest in foundation subject, being it a boring subject. So I will try to make it more lively by interacting with you all people, and it is your duty as well to understand to the best of your capabilities so that you may be in a position to attempt the exam question in the proper perspective. So if anybody wants to say anything, I will wait for 10 seconds, then I will move further.
Excuse me, sir.
Yes, please.
Yes, sir. So actually, I had this doubt. So if you could please share us the screen so that we can write the name of the cases along and other things along with it, sir.
Ma'am, which cases?
Just now, so you talked about three cases. Literally wanted to note down all the names of it. So that is why, sir.
I would love to share the screen, but as I requested to all of you, these are written in the syllabus. These are the same cases. We are going to read it in now onwards. So there
Okay,
is
sir.
no need. We are going to read it. I have already prepared the notes for all these cases as well as the article, which is in syllabus. And I request to all of you, whenever you enter the foundation class, you bring your syllabus printed with you and bring pencil as well as pen along with you so that you may jot down certain things. In my previous class, I requested to all of you that you kindly jot down first case. Before we understand what these cases are, let us repeat that at the cost of repetition only. First case is R versus Morris in your syllabus. That case is decided in 2021 by the Ontario Court of Appeal. I will give you the background of these cases, why these cases, when we studied NCA, these cases were not there. Because I did it in 2020, these cases saw the daylight in 2021. These two cases. First is R versus Morris. Second is Canada Incorporation versus Calais Shepherd. So these two cases tell you to distinguish between the how to take black racism, because there are certain developments which you all may be aware of in US, that one black guy got killed by the police. Then there was a lot of hue and cry throughout the world, particularly in this Western countries, American countries, both in US as well as in Canada. Then people had started thinking that black people should be given a different treatment whenever the law enforcement agencies or the law comes in between. But it was the moral as well as legal duty of the courts not to go away from the principles, which are very fine principles established by the law. So I request to all of you that you should jot down R versus Morris. This will really help you in exams. This is something sentencing case framework. I told you sentencing case framework. And this is on the right hand side, you should note it down. And on the left hand side, first and second case belongs to anti-black racism. Now, when we are talking about these two cases, you may be thinking that what is the need of writing down on the syllabus? Let me say you, when you will be confronted with, say, all the cases, 30, 40, 50, and you will be in a problem of solving the exam questions, then it will be hard to recall that what this case is. Of course, you have read it, you have understood it, you have a compartment in your brain which tells you what this case is. But to help your brain to conceive the things at a rapid speed, you must jot down these fine points upon your syllabus itself, because you need to see the syllabus every time you attempt any exam. And this is the only subject where you need to do this. If you do this, you are good to go for the passing the exam. And believe me, to see 4 words in your NCA account, PASS, pass, is a very, very relaxing time. To see those 4 words, 4 alphabets, in your NCA account, you need to do certain methodological things. And one methodological thing, as far as foundation is concerned, that you should jot down on your syllabus. Second case, 8573123 Canada Incorporation, Calais Shepherd Plaza, landlord tenant case. Landlord tenant case. And you can go above and write down one principle. Judicial notice of anti-black racism in Canada needs to be taken. Judicial notice of anti-black racism in Canada needs to be taken. What is in existence should be brought on record. Whatsoever, what is in existence should be brought on record, howsoever indirect that might be. I have picked these points to help you people in the exam. Now come to the third case, sorry. Third is R versus Gladue. Of course, this is an old case. Judgment came on April 23, 1999. If you want to distinguish in your exam about the time frames, you should write down on left-hand side of this case in your syllabus, April 23, 1999. And on the right-hand side, you should definitely write down section 718, subsection 2, subsection E. Hyphen, purpose and principles of sentencing. Gladue sentencing. This case is also called as Gladue sentencing case. Exactly above, by putting an arrow or write down some dot dot, second dot dot, you should jot down restorative justice must be given particular consideration when dealing with Aboriginal offenders. Restorative justice must be given particular consideration when dealing with Aboriginal offenders. Now come to the, when we are writing down, lastly, there is one article in this chapter by Robin, Mr. Robin, arrested injustice. There you should jot down black racial discrimination. He describes, we are going to read today itself in few minutes, that how black racial discrimination. Let me say you, this article was published as written in the syllabus. Of course, there is one book as well. Some people do ask me, Robin Maynard arrested injustice from the streets to the prison. This is the name of the article which was published by Mr. Robin. And another is the name of the book, Black Lives, State Violence in Canada from Slavery to the Present. So he has written one book as well as one article which has been clubbed together by NCA for the NCA students, but this has got nothing to do with the current scenario which has emerged because of a, I should call it as a murder by a policeman in US, but this was way back in 2007. So this is very interesting how still it is prevalent. The writers goes to the extent that we need to take certain things in our perspective. I will show you my syllabus, how I do it. If you keep on doing it, you will be good. That is how I do it. I have written left, right, and above. What I'm trying to tell you from the first chapter itself, if you will make this methodology, it will be very easy to attempt the exam. Now let us go to case number 1, R versus Morris, which was decided by the Ontario Court of Justice in 2021. The takeaway, I have already told you sentencing framework. Here I would like to elaborate it for indigenous offenders or Aboriginal offenders. Does not apply to black offenders. you have to distinguish between Aboriginal people and black offenders. That is the whole case. Now I have requested one of my old student as well, Satinder. She will read, and then of course you will, all people will have access to those points. And then I will keep on explaining facts as well as the takeaways. Before she start, I request her to read. I should tell you one thing. I have summed up the case in 1.5 page, or more, not more than 2 pages. Very neatly written. What I'm trying to say, you need not to put the whole of the case in the question paper, because up to the last you may be thinking that how we need to bring this case law into our exam. Say there is an independent question, then you have the whole of the case. But if there is not an independent question, then you can always use the takeaway wherever it is appropriate, most appropriate. But for the purpose of understanding, you should read the whole case, whatsoever I have written. If you are still more studious or want to go for intellectual reading, you can Google any case, you can find out on Kennelly, then you can, or you can watch out the Supreme Court cases or Ontario Court of Justice cases, then you can go through the whole of the judgment. But that is not good for NCA purpose. In NCA, we will able to write few lines from every case until and unless there is a full question. I have prepared the material for the full exam question. If there is a full exam question, you are good to go with the help of my notes. May I request you, Satinder? Are you there?
Yes, sir. Yes, sir.
Let us read first R versus Morris takeaway. First is the takeaway I have written. I will attempt the whole of the foundation like this. First, I read the one line by which you can remember the case, which I have already read. Sentencing framework for indigenous offenders, Aboriginal offender does not apply to black offenders. So whenever a judge needs to apply, he needs to distinguish between the two. Black offenders should not take advantage of the law made for the Aboriginal offender. This is the whole case. Now, Satinder is going to read. Take
R versus Morris. R versus Morris, 2021. Sentencing framework for indigenous offenders does not apply to black offenders. The appellate court's powerful declaration is made with the aim of anti-black racism being acknowledged, confronted, mitigated, and ultimately erased. The vital question answered in the case at hand is, how should trial judges take into consideration evidence of anti-black racism at the sentencing stage of a criminal prosecution?
So let me say you, this case talks about that whenever a black offender tries to take advantage from a provision which has been made solely for the purpose of Aboriginal offenders, one should not confuse the black racism with the Aboriginal. Aboriginals have absolutely got nothing to do with black people. And of course, the second chapter is that is why I will like to little elaborate. Aboriginals are the native peoples of Canada. Who are Canadian? Today you say you are a Canadian. Even I will say after a few years, I am also a Canadian. But let me say you who are original Canadians. There are certain advantages for them in the law because of their extreme conditions, because of their native conditions, because of their native living standards, because of their agreements reached between the French government, because of their agreement reached between the British government. So there are, I can count even the 100 factors right away. But you should take into consideration that we have not to confuse ourselves with the Aboriginals and black offenders. And let me say you one point as a piece of caution. In these examinations, the examiner is trying to confuse always I am to say you Aboriginals with the black offenders. And whenever you are going to commit the mistake, you are going to lose marks or you may fail in the exam. So in whole of the exam, this aboriginal must not be confused with the black offenders. Sindar, this is the takeaway whatsoever Sindar has just read, and I have explained you. Now come to the facts of this case. Please.
Facts. In 2014, police was contacted by a man who claimed that he had been the victim of a home invasion and described the robbers as four black men. In response, two plainclothes officers in unmarked vehicles located four black men walking in a parking lot that happened to be in the vicinity of the robbery. One of
Just
the
a moment.
men was Mr.
Just,
Calvin.
just a moment. Whatsoever Sindar is reading, if you have a full-fledged question, these are the facts. We have picked up certain facts from each case law, which are best suited for the NCA exam. On the end of, we always try to put the para number. Why we have written Morris para number 14, Morris para number 15, 17, 18, 19, whatsoever para is there. Why so? To make the examiner realize that we have gone through the whole of the case and we have put our night lamp oil in operation and we have searched the thorough readings prescribed by the NCA. And if you keep on attending my classes, you will on the advantageous position that you will have the reference material for your examination ready-madely available for. Continue, please.
One of the men was Mr. Calvin Morris, who, when approached, attempted to flee and subsequently ran into an officer's vehicle, Morris Para 16. Mr. Morris then scaled a fence and ran into the parking lot of No Frills grocery store, where officers continued their pursuit, Morris Para 17. Mr. Morris then ducked into a stairwell and removed his jacket, whereupon he, the accused, was apprehended. Police later recovered from the stairwell a jacket which contained a loaded 38 Smith & Wesson a handgun, Morris Para number 20.
So these are the facts. These are the facts of the case. We are not here to put all of the facts of the case. We are put only those facts which are relevant to the takeaway of the case. Now coming to the what is the law? Of course, it needs to need not to be written in your examination, but if there is a full-fledged question, then it will have an absolute like upper hand upon the other students. When you tell to the examiner, you need not to write a whole of the section from the criminal code. You have just to say 718.2 A code ... and last three words, means to say this is the way how you can save your valuable time in the exams. You have to tell to the examiner that how the law needs to be quoted, but you need not to put the whole of the sections whenever you quote any sections from the law in all of the exams. What to talk of foundation? Kindly read, Satinder.
Law 718.2. A law that imposes a court that imposes a sentence shall also take into consideration the following principles. Clause E. All available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to victims or to the community should be considered for all offenders with particular attention to the circumstances of Aboriginal offenders.
So this is something about their reading of the law. So this section gives the courts the power to consider the Aboriginal offenders in a different manner at the time of sentencing. The court needs to take into consideration their circumstances, their community standards. So now what was the decision? This is very important. Again, I am at the cost of repetition. I am needs to say you need to put only the relevant part of the decision into your exam. Let us understand what the decision says.
Decision. The trial judge's task in sentencing is to impose a just sentence tailored to the individual offender proportionately to 1. The gravity of the offense, and 2. The degree of responsibility of the offender.
So the
Social
basic principle, the words I have mentioned is sentencing framework. this case has given that how a trial judge should consider when he needs to give sentence to a person who has declared to be guilty. The first point to be taken into consideration is the gravity of the offense. The second is the degree of responsibility of this offender. How much degree of responsibility of the offender, which will bound the judge to give him a harsh punishment. Suppose if the offender happens to be an aboriginal, then a different treatment needs to be given. If whenever sentencing part is there, we have to take it, the judge needs to take into consideration the mitigating as well as the aggravating factors. But while taking the aggravating as well as mitigating factor into consideration, the judge needs to see what is the gravity of the offense and what is the degree of responsibility of the offender. This is the principle as laid down in this case. Next, please.
Social context evidence relating to the offender's life experience may be used where relevant to mitigate the offender's degree of responsibility for the offense. When assessing the offender's degree of personal responsibility, an offender's experience with anti-Black racism does not impact on the seriousness or gravity of the offense. The trial judge erred in this regard. The
To the
Gladue
point in question, in this case, the trial judge giving the benefit of this clause has reduced the sentence. So the court, the appellant court, that is Ontario Court of Justice, has held that he has erred in the law. He should not confuse the anti-Black racism with the Aboriginal, but he should consider offender's degree of personal responsibility. It is not only that this case talks about that the Black people should not be confused with Aboriginals. This goes a step ahead and gives the framework for sentencing. Next, please.
The Gladue methodology does not apply to Black offenders. However, that jurisprudence can, in some respects, inform the approach to be taken when assessing the impact of anti-Black racism on sentencing.
Of course, the judge needs to take into account anti-Black racism, but he should not use the Gladue methodology. What is Gladue methodology? We are going to read today itself in our next case. Continue, please. Last point.
Ontario Court of Justice found that the trial judge could have imposed a sentence ranging from a sentence at or near the maximum reformatory term to a penitentiary sentence of 3 years.
So I have discussed only those points which are relevant for the purpose of exam. But this case discuss in detail that the person was trying to take the benefit that, as you have read in the facts, that he's a Black person. He was spotted by the police being a Black person. And after he was held guilty by the court of law, then he never stopped this formula of his defense and went up to the extent of telling the judge that he should be given the benefit, and trial judge duly given him the benefit. And lately, when the government went into appeal in the Ontario Court of Justice, then Ontario Court of Justice have given this judgment and ruled that the lower court judge, that is a trial judge, has erred in giving the sentence. He could have taken the gravity of the offense and degree of responsibility into consideration rather than the anti-Black racism concept confusing with the Aboriginal offenders. So this is the whole case. I have tried to explain it at length and now move up to the next case. Before we move to the next case, may I ask if anybody has any doubt about this case? Anybody can come forward. Every question is a very good question, because until and unless you will have questions, you will not able to understand fully.
I have a question.
Please.
We discussed initially that everything should be related to this legal theory. I was just trying to relate this case with the legal theory. Which legal theory can be related to this case?
What do you say?
Like initially, we discussed that judge gives decision based on these legal theories, what we discussed, and these legal theories are base for every question that will be attempting in exam also. So considering this R versus Morris case, which we just discussed, can be related to any legal theory which we discussed, or it is independent?
It is independent. Let me say you one thing more. To give little elaboration on your point of view, there will be a fact pattern which will be given in the exam. You will have
Okay.
to correlate two things to that fact pattern. That is, needs to see the case law as well as the legal. So,
Okay.
among say 20 cases are in your mind, when you read an exam question fact pattern, you come to know this case is relevant. This case, then after a few minutes, you say that this case is not relevant. Then which is the legal theory which is most applicable? In the end of the your thinking process, say for 2 minutes, I will always guide that you before writing foundation answer, you should have a concentrated effort of 2 minutes, and that those 2 minutes are really going to decide that what to write in the reply to the exam question. You may come to a conclusion that you are not able to write down any theory into the question. If you go one by one, rule out theories there. Whether we can write anything from the legal positivism, no. Write anything from the natural law, no. Something from the critical legal theory, somewhat yes. Why so? Because life experiences somewhat like this. You may say that, like in this case, what the judge said from the, if we want to correlate somewhat, I'm not saying the degree of responsibility of the offender, as well as the offender's life experience may be used where relevant to mitigate the offender's degree of responsibility. If the judge wanted to reduce the sentence of the offender, then he needed to take into consideration the life experiences of the offender. Then all of a sudden you are reminded that we were talking of the decision maker. Here we are talking of the offender. Then you come to a conclusion, no theory is applicable, like critical legal theory is also not applicable. Then you come to the next point, then whether any point from feminism, no, outrightly rejected. Then any point from the law and economics, no, gone. It is applicable.
Okay, sure, yeah. Thank you so
So,
much.
like this is the process by which we should rule out the things. We should take the help of the syllabus. And once you will be good with all the syllabus, then you will be in a position that how to attempt the exam. Any other question before we go to post case number 2?
Thank you.
Welcome. And I'm taking much of the time in explaining the thing, because we are building our base. Once base is there, we will be able to understand every question, every like case law at a rapid speed. You may see that in the days to come, my speed will be increasing. I'm slow because I want to build up your base to understand the concept as given by NCA, and you need to memorize those concepts in your mind. Why I use the word memorize? For the simple reason, because you should have something in your mouth, in your mind, accompanied by a few words written on the syllabus. Satinder, are you there? Let us read case number 2, which is concerned with land 8573123 Canadian Incorporation. If anybody is not familiar with this 8573123, what is this? This is the name of the company. In Canada, the name of the companies can be digits. Any numbers can be the name of the company. So if you want to name of the company, that is extra knowledge I am giving you. 8573123 Canadian Incorporation is the name of the company, versus Calais Shepherd Plaza, which is the name of the plaza. Landlord tenant case relating with commercial tenancy. And let me say you one thing before we start understanding this case. In this judgment again came in 2020, related with anti-black racism. Two things are in your mind. now you will see how it impacted the whole commercial world. Before it, the landlords thought they can deal their tenants in the manner they like. Court are not going to take any cognizance because it happens to be the civil cases. It decides the rights intersect and court will not take cognizance. But this case brought a sea change in last year in the thinking perspective of the like professionals. This case held that anti-black racism do make a difference in civil cases as. Let us see how. Let us first read Sindar start from judicial notice.
Judicial notice of anti-Black racism in Canada needs to be taken. What is in existence should be brought on record, however indirect that might be. The,
So I have already explained it, please. Next.
the Ontario Court of Appeal took judicial notice of anti-Black racism and factored in a racial prejudice on the part of a landlord to grant a tenant equitable remedy of relief from forfeiture.
The point in question is based on anti-black racism, because what the land we will be studying in the facts. Just a moment, please. We will be studying in the we will be studying in the facts that once a judicial notice is taken of anti-black racism, how is going to impact the equitable remedy. Equitable remedy is that remedy which gives relief based on law of equity. Generally practitioners, I should call it as, practitioner give least importance to the law of equity or give the most importance, because whenever they feel like they can adjust their actual situation to best suited to the law of equity. But this is not the case. So here the court has made a very strong recommendation for the times to come that how law of equity needs to be used. Let us go to the facts, please.
Facts. The tenant 8573123 Canada Incorporation operates a family-run restaurant serving African and Caribbean food from its premises in a shopping plaza in Toronto under a lease with the landlord Kelly Shepherd Plaza Incorporation. The term of the lease was originally for 5 years, and the lease held that the tenant had 2 renewable options to extend the term by written notice to the landlord at least 6 months prior to the expiry of relevant term, para 3. Although the tenant failed to strictly adhere to the terms of the notice provision, the tenant made significant efforts both before and after such notice deadline to contact the landlord and communicate its intention to extend the term. The landlord kept the tenant in an overholding position from August 2, 2017 to May 28, 2020. Ultimately, the landlord issued a notice of termination to tenant. The tenant then sought relief from forfeiture from the court. The tenant respondent sought equitable relief against penalties and forfeitures on such terms as to compensation or otherwise as are considered just.
So you have gone through the facts. This is purely a civil law question to be decided by the court. Now you need to see that a tenant who forgot to comply with the conditions laid down in the lease agreement itself still got the benefit because of the fault of the landlord. In this, the landlord used certain anti-black racism words in the court of law. That is how the judge, I have included into the decision. Sindar, kindly read the decision. Now you are conversant with the facts. Kindly keep all these facts into mind. Now let us go to the decision.
Decision. The Superior Court found that the tenant made significant efforts to reach the landlord, both before and after the notice deadline, to negotiate an extension, including via correspondence from the tenant's lawyer, which Justice Morgan found were purposefully ignored by the landlord and its property manager. In its affidavit, the landlord stated that it sought to replace the tenant with a more suitable business, as the tenant did not attract like-minded family-oriented customers, and submitted that tenant was operating a liquor bar which detracts from the appeal of the plaza. Though, as the judge noted, the tenant itself was a family-run business.
So stop, please. Here, this is the only takeaway if we are to talk about the facts, that in its affidavit, the landlord stated that it sought to replace the tenant with a more suitable business. The tenant didn't attract like-minded family-oriented customers. As you might have noticed in the first line of the facts read out by Sitinder, that it was a family-run restaurant serving African and Caribbean food from its premises in a shopping plaza in Toronto under a lease with the landlord. So what I'm trying to tell you, that this was a black people, and the landlord never wanted, was in a way looking for an opportunity by which he can terminate the lease of his tenant, that who is a black person. Of course, he was, his lawyer as well as he himself was sensible enough not to say this in court, but he could not conceal his intentions from the court by saying that like-minded family-oriented customer. This has been quoted by the Ontario Court of Justice. Nothing is coming from my mouth. This is entirely from the judgment. And these are the facts which a judge needs to take notice of. Whenever the judge needs to reach at a just decision of a case, these are the quoted words: like-minded family-oriented customers, and submitted that the tenant was operating a liquor bar and detracts, and submitted that the tenant was operating a liquor bar and detracts from the appeal of the plaza. So he wanted that he should be thrown away from his plaza. Continue, please.
The real issue for appellants is that the tenant is a black-owned and operated business and caters to an Afro-Caribbean community and refer to as stereotypical labeling. Para 13. The Court of Appeal, the application judge was entitled to conclude anti-black racism was relevant to the landlord's refusal to negotiate a renewal of the lease, regardless of whether the landlord's actions were consciously motivated by racism. Para 15. The Court
Just
of
a moment,
Appeal.
please. Before we go further, I would like to here to know which theory comes into operation. Like here, the court is saying that the tenant has forgotten to issue a notice as was required under a lease. That is in fact admitted by the tenant. Now, the preposition before the court is that the landlord never allowed the tenant to make a negotiation. Now, which theory comes into operation? Anybody
Natural
can.
law.
Law, rule is a rule is not the theory over here. Natural law theory, that certain principle based on the moral values should be brought. So this is how you need to incorporate. What is law of equity? Law of equity is nothing less than natural law. Law of equity is based on otherwise also natural law. But facts speak louder than what I just stated. Please continue.
The Court of Appeal dismisses the appellant's appeal, finding the application judge was entitled to take judicial notice of anti-black racism in Canada and no basis to interfere with the exercise of his discretion.
So the point in question is, this is a landmark case for the times to come for the commercial tenancies as well as other business houses, because it is going to impact the industry in Ontario and in Canada for a long time to come with respect to the anti-black laws. Here, there is no, this is something purely an inter-se relationship based on a written instrument. The law says something different. So where we had started, where we have reached. Once you know the crux of the matter in a proper perspective, then you are ready to quote this case, or you are ready to tell to the examiner. Suppose there is an independent question on this. I have written in my notes, which I will read. One question can be, in what circumstances should a court take judicial notice of anti-black racism in Canada? This can be one question. Suppose you will have access to this, no need to write down. Another question can be, is there a principal basis to consider or not to consider anti-black racism, or are societal realities pertaining to black business people always to be taken into account? Whether the black people business houses always at the mercy of the white people? Answer given by this question is absolutely no. The courts need to take cognizance and decide the cases accordingly. Another question can be, is there a requirement to provide evidence of unconscious bias, and if so, how is this demonstrated? Whether the landlord just avoided the tenant to come forward and negotiate lease terms generally, or there was some bias. He was biased because he wanted to kick black from his plaza. So that is how you need to understand. So this is all about the second case. If you all have gone through, now I have tried to explain that how you need to interwove the legal theory as well. Any questions, please?
No, sir, all clear.
Anybody else? If any question, before we go further with Gladue sentencing. Now comes the third case, R versus Gladue. Purpose and principles of sentencing. Why I'm stressing so much on this case law and articles? Because in the previous times, in our times, when I did NCA, the examination pattern was entirely different. Now NCA is becoming stringent day by day. They are making examination tough for every student. So we need to prepare the subject according to the current needs of NCA. These notes are allowed in the exam. You can make your cheat sheets, you can take elaborative notes, you can take precise notes, you can take books into the exams. You have everything in your mind, but still, what NCA is looking for? NCA is looking for application of mind. And why you all people are in this class? You all people are in this class just to make that application of mind clearer to you. This never guarantees you have to apply your own mind in examination. But let me say you, if the concepts are 100% clear in your mind, question may be in any manner, you will, when I will share these notes, you will come across that these simple one case is big enough to cover 20 marks question in the exam, or 25 marks question in the exam, 1/4 of the exam or 1/5 of the exam. So how important, that is why we are spending so much of time. Let us go to another question, another case. Next case is R versus Gladue. It was decided in Supreme Court of Canada in the year 1991. So old case, but relevant till today. So in first case, we have read that nobody should confuse black with Aboriginal. Now, whether the Aboriginal person can take the benefit of section 718 subsection to subsection E. There are words written. Everybody can read it. But this case tells you, even if your offender is an aboriginal, even then he can be debarred from taking benefits of this section at the time of sentencing. Here we are talking about sentencing, nothing else. So once we are talking about sentencing, in first case we were talking about sentencing, in the last case we are talking about sentencing. Now see why NCA has chosen these two cases, because these two are extreme. First talks about black people, Aboriginal. Now this case talks about Aboriginal and Aboriginal only. In this case again, you will see that Aboriginal was not given benefit of this section. Purpose and principles of sentencing, Gladue sentencing. Now comes first to the takeaway. Why I have written takeaway separately? Because generally in the examination, you need to write 2, 3, 4 lines. Now every student keeps on asking the teacher, various other teachers as well, to me as well, that what to write in the exam. Here is the answer. Stinder, kindly read. First,
Restorative justice must be given particular consideration when dealing with Aboriginal offenders. Gladue was the first case where the Supreme Court considered the interpretation and application of Section 718.2, subclause 10, subclause E. It also set out factors which the sentencing courts are to take into
Stinder,
account.
sorry for this. I suppose 10 has been misprinted. It is subclass E only.
Okay, sir.
Please
Take
continue.
into account in applying Section 718 subpoint 2 clause E. In the years since the decision, sentencing judges have directed that to assist in sentencing indigenous offenders, pre-sentencing reports be prepared to assess the factors which the Supreme Court has identified as being considered under Section 718.2 subclause E. That type of report has become known as a Gladue report.
The point in question is, there is a fashion nowadays, fashion I would call it as, to ask 2 marks question in NCA. What is Gladue report? This is something certifying what is Gladue report, a report which is prepared to bring on record the circumstances of an original offender is before the sentencing process is known as Gladue report. And I have put it in fancy words in my notes. You can copy paste, you can slightly change so that the examiner may not be accusing you of copy. So now let us read the facts of this case, then we will be good with this case. This is a very easy case. Please go ahead.
Facts. Jamie Tennis Gladue killed her common law husband on her 19th birthday and was charged with second-degree murder. She suspected her husband Rabian Weaver of infidelity at a party earlier in the evening. Her husband intoxicated Gladue to the extent that her blood alcohol level was double the legal limit. Later, Weaver confirmed his infidelity and insulted Gladue during an argument upon returning to their townhouse. Gladue stabbed Weaver in the chest after chasing him from home with a knife. She pled guilty to manslaughter but appealed her 3-year prison sentence on the grounds that the trial judge failed to give appropriate consideration to her circumstances as an Aboriginal offender.
The law remains to be the same, section 7182, subsection E, which we have already read. Now come to the decision. You are all that she did murder of her husband. She was living somewhere else. She did murder. Of course, there are certain facts leading to that. Her husband was not sincere to her, and she admitted that he was involved with some woman in the beginning of that evening, and later on she stabbed her husband many times in her chest. She was admitting that she has done manslaughter. Of course, this is a criminal law question, that whether she will be tried for second-degree murder or manslaughter, that needs to be seen in a laboratory manner, but we are reading foundation. So as such, we need to concentrate upon the foundation part only. And foundation part is that whether she is entitled to any sort of remission under this section as an aboriginal offender. That is precisely the question is. Now, what is the decision from the foundation aspect?
Decision. The trial judge found that she was not living on a reserve at the time of the murder. As such, the said section did not apply to the case and sentenced Gladue to 3 years in prison. The Court of Appeal did not interfere with the trial judge decision. The
Just a
court,
moment, please. The trial judge took just one point, that she was not living on the reserve. That's all. Once a person is not living on the reserves, what is reserve? We will of course read it in second chapter. Who is an aboriginal? When a person ceases to be an aboriginal, when a person can be given benefit of being an aboriginal, that we need to understand for the purpose of constitutional law as well as foundation law. But as far as here the point is, the trial judge based his opinion on the fact that since she was not living on the reserved land, she cannot be given the benefit of being a aboriginal. I already told you the life circumstances needs to be appreciated at the time of sentence. Now come to the last point, which is very important for the examination. If you have to give simple reference, then this last paragraph is most important. You can put some lines into the examination. You are going to get good marks. Sindar, please read.
The case went all the way to Supreme Court of Canada, but Miss Gladue failed in her attempt to reduce her sentence. In spite of this failure, the judgment is being hailed for interpreting and applying the new sentencing provisions set out in Section 7.8.2. Subclause E of the Criminal Code in a way that will sensitize the judiciary to the unique situation of Aboriginals and end the alienation of Aboriginals from the criminal justice system.
So this is a quote from the judgment which you need to quote. That is why I never interrupted Satinder. The point which I am trying to make, that you need to take the personal circumstances of individual offender, even if he or she happens to be an offender. Of course, there are detailed facts which can be discussed, that how she was not living on the reserve, why she shouldn't be given the benefit of being aboriginal when she was a aboriginal or not. That is a debatable question which can be discussed separately, but not for the purpose of our examination, for the purpose of our foundation. That is why I have chosen only those facts and takeaways or the decision process which is ultimately relevant to our exam. Any questions from this case before we proceed to the article of the day? Let us go further without wasting any further time. Black. We have discussed the cases that has got a different paraphernalia for thinking. We have discussed concept. Why I spent so much time on chapter 1. People do say me, you have spent 2 classes, which was not sufficient, which was not required. Well, I say that these first chapter makes this. That this chapter enables you how you are going to understand foundation in totality. Because in the first chapter, there are only 3 cases. In that chapters to come, there will be many cases. I will be moving very fast. You have to catch the part which is relevant. Why it is relevant, I need to tell in the first instance. I'm not going to repeat time and again in the days to come. We will be covering the whole of the syllabus in few classes, means to say 15 classes or at the most 16 classes. So What I'm trying to say, I need to tell you how you need to understand the cases from a different perspective, which is the perspective of foundation class. Now let us go to the article part. I will not read this article whole of the good. I will discuss few points. This is an article, as I already told you, there are certain takeaways. It is reality, not less than a reality. In American countries, northern on any countries, North America, that black are being treated in a different manner. I won't put that different manner into words. Black racism is there, anti-black racism is there. The point to be noted that this author, Robin Maynard, is trying to depict that even in the contemporary times, black are given the worst treatment, which is continuing from very olden times. For the sake of change, or for the sake of, what do you call it as, bringing bad people to book, never allow the law enforcement agencies to treat the black people with disparity. The black people should be treated equally as citizens of Canada. As I have already told you that this is not the truth. Black people are still considered inferior or in particular offenders. Same act, if done by a white person, is not treated as an offense in Canada, whereas whenever a black person is spotted doing the same act, is treated to be an offender. So this is the crux of this whole article. This whole article talks about these points which I have just made. This article has been split up into different categories. The author first, I have written this article. This article is of 32 pages, 33 pages. I have summarized it into spaced space of 3 pages, less than 3 pages. So it is there will never be an independent question. Even if it is an independent question, this is sufficient material to be written along with your own opinions on each and every point. The first point which the author makes is racialization of the crime. That the crime should be treated as a crime, whereas in Canada, profiling of the black people is being done. Black people are spotted. They are targeted group. Whenever a crime happens, police is after the black. And this is not done. Even if you keep on spotting a particular community, particular tribe, with one set of notions, you are trying to prove that those people are the real criminals. So the racialization of the crime should not be there, but it is being done in Canada. I have written in detail with reference to everything that how the racialization of crime is being done with respect to the anti-black people. This, the author further says that no freedom is there. They cannot move freely into the society because the police put certain restrictions on the movement of the black. This seems really hard to believe. This is my own notion that in today's scenario, when we are living into the 21st century, is there anything like going on in our society, in Canadian society, which is considered as the best societies in the world, most peace-loving, peaceful countries in the world? But Canada has got its own shortcomings, which particularly the policing and the judicial system, which the writer is bringing on record by way of his observation by quoting different. So I have mentioned that how police profiling of these black people is hindering the movement of black people into the society on a free basis. Then comes that Canada has, rather almost all the country has declared a war against the drugs. But war on drugs never means that you should pinpoint the black people. I shouldn't say that whenever a crime happens, whenever drugs are seized, then the people, black people, are targeted first. It is being said that in Canada, it is not a war against the drugs, it is a war against the black people, which has been started by the government. That is another categorization which the author does in this article. Then the author goes on to say that from the streets to the courthouse, even in the courthouses, black persons are treated indifferently. They are not given that treatment as an offender. Suppose a bail is to be granted to a person. If a black is an offender, then criteria will be different by the judges. If white people is the offender, the criteria will be different by the judges. So the author tries to say is that it has not ended even in the courtroom. In the courtroom, even if there is a question of bail, there is a question of sentencing, there is a question of anything. Even if after sentencing, parole needs to be granted to a black person, his application is treated in a different manner, which puts the black people on the back foot. Means to say they are not being treated equally as all other citizens are in the court. So the author tries to portray a situation in which black people are not treated equally into the court, even in the courtroom. Then comes a person who is detained, who is put behind the bars. He is treated differently. Totally differently. They say that they say means to say, this author says that whenever treatment into the prison is concerned, keeping the offenders into the jail, providing of food or providing of the health benefits to the offenders in jail is concerned, black people are on the hit list. They are not provided with medicines, they are not provided with proper medical care, the food is, they are provided with different sort of food in the jails. That is based on his research experiences, that he gives certain data as well, which I have noted down in my synopsis as well, which I have made from this article. So the author says that those jails are not jails for the offense which has been committed by a person. Those have turned to be a captive houses for the black. So these are the author's views. Let me say you one thing before I go further in this article, that you need not to put your own views into any articles. These are purely the views of the author. You are to take supportive view of the author in your answer. You are to put relevant part of the article into your answer. But if there is a independent question, which is most unlikely, but there are questions being asked by NCA in your exams based on each individual article, then you need to describe whole of. But the golden principle, which I am going to tell you, in any of the articles, these are not your opinion. You are not to write, I am of the opinion. You cannot give your own opinion in any article. You are describing writer's opinion. So whatsoever I am telling you, this is not my opinion. This is writer's opinion, Mr. Robbins' opinion. Whatsoever Robin has felt with his fact and figures, that you need to mention in the exam. Then comes the prisons. He talks about the prisons, that every sort of discrimination is being made in the prisons. Prisons are reformative houses for the offenders, whereas for the black people's prisons have turned to be undesirable places where they are not reformed to become good citizens, but they are forced to become criminals. That is what writer is kind of. Writer is saying that prison should be reformative houses, whereas the prisons are becoming the training centers of to become criminals for black. Now, to conclude, again, you are not to give your own conclusion. The conclusion is always by the author. In conclusion, the writer says, of course, there are fancy words attached to it. I have written down in my synopsis. Crux of the matter is black people are being discriminated from the beginning of the crime till the end of the punitive procedure. Even after that, they are labeled as criminals, they are treated as criminals, and they are guided to become criminals even if they are not. That is the crux of it. That is what I have tried to portray before you in the last 15 minutes. So I have tried to tell you the different opinions of the writers as written in this article or as written in his book, Black Lives, State Violence in Canada from Slavery to the Present. They say the writer is of the opinion the state is doing oppression, violence upon the black. By writing this article, the writer wants to bring the atrocities which are committed by the state or its machinery upon the black people in every possible manner. Now let me say you about something else as well about this article alone, so that you may read further articles with the same perspective. Any line which I have spoken in the last 15 minutes is not written in my synopsis, except 2 or 3 lines. I have spoken the opinion of the writer in my own words. That is what the examiner is looking for, even if an independent question comes from article. And please, please, please don't think up to the end of your exam that there will not be an independent question. There can be an independent question. Examiner is trying to adopt different methodologies upon NCA students, And believe me, he is going away from the past practices. What are the past practices you should never consider? That is my way of thinking. My pure advice to you people all is that you should concentrate upon your own logical thinking in the foundation exam, and you should not bestow upon the past practices of the examiners which they are not going to repeat or which they are hardly repeating. So you should prepare this foundation subject as a fresh. That is my humble advice, request to you all. And if you carry on my instructions, you will be good to pass the exam in first go. That is how I attempted all my NCA exam in first attempt. What I am trying to portray, I am not trying to tell you that I did it in first attempt. There is a methodology attached to it. If you follow that methodology for the each subject, you are bound to pass this. Nobody can stop. But if you are going to copy the methodology, you are going not to follow your own principles which you make during your class, then you may fail. So avoid that, make your own methodologies. I suppose you will be good to pass the exam. Any question from this article or journal question is always a good question.
No, sir.
Sindar always say no because she reads, and anybody can. I will be providing all these which we have done 3 cases and one article to all of you. You can think upon, and let me say you one thing also. There are few students who are already enrolled with me for this NCA foundation course, and you all are welcome. You can ask your friends to join classes. We will have next time we will have one class on Sunday, but in the days to come we will have 2 classes on Saturday and Sunday. Each class will be ranging from 1 hour 30 minutes to 2 hours, and we will be completing our syllabus well before 16th of July. 16th of July till date is the starting time of the exam, and students who are preparing for 16th of July examination, we will be completing. This is only for those that we will be completing our syllabus, including exam workshops, by 10th of July or whatsoever the last Sunday will be. We will be, or even before that, because we will be having 2 classes. And I have tried to explain the whole methodology. Still, new suggestion, new methodology is always welcome in my case. I always welcome, I always try to experiment with the new things if those things are best suited. If you convince me, I will follow you. If I convince you, I request you to follow my methodology. Any other question, you are welcome to enroll. You can give me personal message. We will be holding next class on Sunday, the same time, 7 p.m. Indian time, 9:30 p.m., 9:30 a.m. Toronto time, 6:30 a.m. Vancouver time. And I suppose anybody can enroll, whosoever will be listening my classes on YouTube as well. They are welcome to join. But I request all of you to kindly keep abridge yourself with the continuing class so that you shouldn't pile up the classes. Generally, people ask me for foundation, would you be providing the recording? I say yes, but I say no as well. Why so? Because the recording is not going to phase your mind into different compartments. If you keep on listening the recordings from morning till evening, you are not going to reach anywhere. I can hold classes twice, thrice, or 4 times a week, but if you keep on studying once or twice a week, you will be good to go for the examination. Of course, you need to read thoroughly during the week, and you should prepare the question. My methodology is to take up the questions in the class with a little repetition, with a little revision, and then if you have good questions for me, I will be very happy, and I will be in a position to understand how you are going preparing your course. Any questions, please, before we end up our class for the day? Thank you very much. You have given a lot of your time into these two classes. Even if you don't join my classes, you are welcome to ask me any question briefly on WhatsApp or by calling me at an appropriate time. It was a good time for me explaining you all the concepts. I suppose I may be clear on certain aspects which you are looking forward. And thank you very much for your precious time, all of you. Thank you.
Thank you, sir.
Thank you, sir. Thank you.